Take care of yourself and take care of your family. Is my slide visible?
Yes, sir. Yes.
Yeah. And I'm sure that I'm audible.
Yes, sir.
So
Good morning to all of you. Uh, Today's our section is dealing with Dr. Lawwellman sir, assistant professor in Government Law College, Kozhikode, and then he is carrying selected a PhD in his topic intellectual property, right? So this session will be useful and maximum attend, and so we can start now, sir.
for the introduction, and just I'll start with a clarification. Today's poster about the program said copyright. I'll be dealing with the subject copyright, but please kindly note I'll be dealing with the subject patent. We had enough of time, or rather, a reasonable uh, time and reasonable days spent on copyright. And today we'll be moving to the area of patent. Today will be the first day on patent, and we will continue with our discussion on patent for a few days. That's what we are going to do. So with that clarification, I would begin. I hope all of you are doing fine. Be happy. Being happy is a choice. Somebody told, and I understand that is so. So if you want to be happy, you can put happiness into your subconscious. I think that can be done. If you earnestly take some effort, be happy, you can be happy. Of course, it's not the subject of intellectual property, but I thought I'll wish this to everyone. So keep smiling and be happy. So coming back to intellectual property rights. As we all know, you're all teachers and scholars. We have 8 areas of intellectual property rights. When we say intellectual property, it goes without saying that it means more than one item of property. Or so to say, there are as many as 8 items of property. So 8 items of intellectual property are, it could be copyright, which we already discussed. It could be patent. It could be trademark. It could be industrial design. It could be semiconductor chip protection. It could be geographical indication. It could be plant variety protection. It could be trade secret. So there are very many items of intellectual property. And as our attempt, our joint venture here is to achieve the target of UGC net, we will be keeping in mind the syllabus for that. And if you have flipped through, if you have gone through the syllabus of UGC, the intellectual property subtitle, when you go to the syllabus of UGC net, intellectual property subtitle includes 80% of intellectual property and 20% of cyber law. And even in 80% of intellectual property, there are 3 areas which are important. The three areas which are important are copyright, patent, and trademark. And in that, we already discussed copyright. We completed it. Perhaps in my thinking, the lengthiest of our discussion should be and should have been in copyright, and that area has been covered. Of course, it's not that we have completely did it, but we had a reasonable discussion. And today we are moving to patent. I thought I'll just give a recap of what happened so far, and I'll put things in perspective and in context so that the newcomers will have an idea about what's happening and what has happened already and what's going to happen. And if you think about patent, I'm sure that patent is something which we all are familiar with, because patent is, without a study of patent, without a discussion of patent, you can't study intellectual property at all. And all the scholars and the teachers here, I'm sure, that had intellectual property paper during their LLB and LLM days. So we are all familiar with that. Patent is a kind of intellectual property where a person is given protection for a kind of technological innovation. Technological innovation. It is related to science and technology. It is related to innovation in the area of science and technology. It is the inventor who is ordinarily granted patent. And the law that deals with patent in India is Patent Act 1970. I invite the attention of my esteemed participants over here online to the screen as well. So Patent Act 1970 as amended from time to time. And the most important amendment being the 2005 amendment. And as we know, patent is a bundle of rights. It's a club of rights in respect of an invention. To draw an analogy with an ordinary, more popular example, when we say we have right to property, right to immovable property, that happens in this fashion, in this manner. There is a 10 cents of land over which Shruti, one of the participants here, has certain rights. She has the right to use, she has the right to enjoy, she has the right to modify, she has the right to transfer, she has the right to distract, and to do very many things. So that club, or that bundle of rights, the bundle of legal rights, that bundle is known as property. So is the case with intellectual property, and so is the case with patent also. In the case of patents, the subject matter of property is an invention, and what you have is the rights you have are right to make, right to use, right to sell, right to import, right to export, and so on. So it is a bundle of rights, as in the case of other properties also. And the right is conferred on, as you can see, so right is given to, right is conferred to the inventor, or to the assignee of the inventor, if as in the case of any other property. This kind of property also can be transferred to someone. 10 cents of land can be transferred to someone. So they can transfer that to Jinxia. So is the case. If Miss Shruti is the inventor, she can transfer that to Miss Jinxia. So Miss Jinxia is the assignee. Or legal representative. Legal representative would mean the person who would represent the original owner. In case the original owner is not there in the unfortunate eventuality, or if the person is incapacitated, or if you're talking about a legal person, it is if think of a situation, a company takeover, the company which takes over the earlier company, who was the inventor, who was the patentee, on whom patent has been granted, is known as patentee. So if the patentee company is taken over by another company, then what happens is the company, the subsequent company, will be the legal representative. So that's a common sensical understanding for a legal person. And another notable feature is right, patent right is for a limited period of time. It is not a perpetual right, as in the case of other properties like right to land, right to movable property, and things like that. So moving on to the next slide, the question we should be asking as a preliminary question: what is patent? So patent, to put it in simple words, it is an exclusive right, or it's a cluster of exclusive rights in respect of an invention to prevent third parties from making, using, offering for sale, selling, or importing for those purposes. So these are the rights available. So the rights available are right to make the invention, or the product of invention or process, to right to make use of the process involved in the invention, to use it, offer for sale, sell it, import it, and of course maybe to export it also. And that is given exclusively. That is something which we all should be keeping in mind. Exclusive is an important word there, or rather, exclusivity is the most important feature there. When a person has a patent right, that person or that company has monopoly, I would say, over in respect of that particular invention. Only he or she can make that product. Only he or she can use that product. Nobody else can do it. If somebody does it, the person can stop it with assistance of law. It's a kind of legally sponsored or law protected monopoly. Though, as we all understand, as perhaps many of us would have the opinion that monopoly is bad. But here there is a situation where monopoly is being granted by law itself. Of course, monopoly for a perpetual period is not good. Monopoly is for a limited period of time, but it is there. And there are justifications for it, which we'll go into. Let's move on. So what's the purpose of patent? Why patent is granted? Every law has a purpose. Law is just an instrument. And if you borrow from sociological school of thought, to put things in perspective, you can say law is a social instrument of social transformation, you would say. I'm sure that you all have gone through law in social change or law in society paper during your LLM days, the compulsory paper. So what the relevance of that here is, the statement here is the purpose of patent, the purpose of this particular instrument, a commercial instrument, commercial law. So it is a kind of quid pro quo. Quid pro quo is nothing new to us. Even if you are a first semester student of 5-year course LLB, fresh off your plus 2 to a law school or a law college, I'm sure that you will have come across this particular phrase, quid pro quo, which is not English. It means something in return. Something in return. And the policy of this particular law says, the patent right is a quid pro quo of the invention. That statement may not make things very clear. I may have to add a few more sentences to it to make that sensible to the group. The law looks at a patent like this. The company or the person who comes out with a new invention, say, for example, medicine for COVID-19 or a vaccine for COVID-19, definitely it has a value. The company or the person is adding something to the knowledge stock of humankind. He is giving something to the society. Definitely it is going to be useful to the society. So when he gives something, as every one of us are, all people are selfish in some sense. So unless there is something to incentivize, the person may not come out. When you speak in the context of a company and in a commercialized sense, nobody is going to invest. A company is not going to invest so much, maybe 100 crore or 50 crore or more than that, into the research and development wing, unless the company is sure that they are going to get something in return. So when they are ready to do that, they should be ensured that they will be given some sort of exclusive right, monopoly. So that will be a kind of incentive that is given to the persons for 20 years. And I'm sure that you all know that 20 years is a period of patent. So the person or the company gives something useful to the society, and society, there's a representative of which is the government, and the law is one of the instruments of that, is giving back monopoly right in the form of patent. That's how it goes. And incentive for the innovation and investment. The person who is putting his hard labor, he's an intellectual laborer for very many years perhaps, and a lot of investment is going in. And these two cannot be encouraged unless you give something in return. And there is another advantage which the patent law is trying to serve. The patent law is trying to serve the society by asking the patentee or the inventor or the company or the person to disclose that invention to the public. There is an essential prerequisite for patent protection. The prerequisite is that there should be a registration. So with the registration application, there is a techno-legal document that is filed, and that document is known as specification. Specification is the document in which the patentee or the inventor disclosing the best method of working the invention. So that is given to a government office called patent office. We have 4 patent offices. So that becomes part of a public document. So that's being disclosed. So that particular art or that particular technique, that particular knowledge would come out to the public. That gets added to the society. So this disclosure is also one of the major purpose the patent law is trying to serve by making that available to society. So that's a policy of patent law. That's the purpose of patent law, which you might get a question on. So let's think further. What are the types of patents? We can think of 2 kinds of patents. One is product patent and another one is process patent. So to make more sense of product patent, this sentence will be handy, I feel. In the case of a product patent, the patent is in the end product or the article. For example, that is in a machine or a substance. It could be a machine which can count and give away money. Automatic teller machine, which during my younger days, I can only dream of. I never dreamt of a machine. Even I never dreamt of a machine which could count and give away money. But today it's a reality. That is made possible maybe because there are people who can invest into it, who can invest their intellectual labor into it. Now we have a machine for that. Or electronic voting machine, EVM, could be another example for this. Or it could be a substance like medicine, or it could be a vaccine. So all these, the end substances, the substance on which you have a right, exclusive right. Only you can make it, only you can use it, only you can sell it. If that is the situation, And if you have a particular substance in respect of which you can say this, then you have a product patent. Then in contradistinction, what is process patent? In the case of process, the patent does not lie in the end product, as we said. It is not in the machine as such. It is not in the medicine as such, but only in the process by which it is made. That is to say, a method or manner of manufacturing something. Perhaps to give a simple example, the pharmaceutical product or the medicine is already available, but the present process or the present manner of manufacturing or present method of manufacturing is very cumbersome, expensive, and time consuming. And if you have come out with a new process method of manufacture, which is less cumbersome, less expensive, and it could be easily made, it is less time consuming, and it is technologically technologically better. That way, you can say that you have a better, technologically innovative, you have a better process. And if you have if you have such a thing, you have a process patent. This is a very simple example. The things are not that very simple in patent, as my understanding goes, but I think the idea is conveyed. Does that convey idea, Ms. Rudy?
Yes, sir.
Does that convey the idea which I wanted to convey?
Yes, sir. Yes, of course, sir.
Thank you. Just to have that continuity going. Yeah. Moving further, what I have for you on screen is a patent document. This is a patent certificate, and I invite your attention to this. This is granted by Government of India, and the specific office which grants patent is the Patent Office, and the certificate is patent certificate, and it is granted under patent rules. If you go further with the patent certificate, you get to see you have a patent number. Here the patent number is 236495. That's a unique number which a patent has, which is assigned by the patent office to every patent. So in this particular case, this is the patent number, and there won't be any other patent in Indian Patent Office with the same unique number. Obviously, when we say unique, it is unique. And now you have application number also, 937 bar CHE bar 2005. It means it is the 937th application in the area of chemicals made in 2005. That's how it should be read and understood. And date of filing is 13/7/2005. That's also important because it is first come, first serve basis that the patents are granted in the patent office. So priority date of filing is of utmost importance. Now the patentee here is Vision Research Foundation. So it is to this particular company that the patent has been granted, and this company is the patent here. And it says it is hereby certified that a patent has been granted to the patentee for an invention entitled such and such thing. What I could make out from the people who are working in this area, like microbiology and all, this is something like our RT-PCR test. And so that's what the people are trying to get a patent on, and they are being granted a patent. And as disclosed in the above mentioned application of 2005, for a term of 20 years, from 13th day of July 2005, have something to explain to you here also. 13th July 2005 is the date on which application has been made. Kindly note. But I invite your attention to the foot of the certificate, wherein date of grant has been mentioned. Date of grant is 5/11/2009. So it's it's more than 4 years since the application is made. So it takes more than 4 years. But patent right dates back. Once granted, it is available to the person from the date of application itself. And the period of 20 years, which is the limited period granted in the case of patent, which is available to the patent in the case of patent, starts to run from the very date of application, not from the date of grant. That could be a tricky question, which UGC question paper center might put forth. Okay, so kindly keep that in mind. So it is from the date of application that the patent term will have to be calculated in accordance with the provisions of Patent Act 1970. And it is signed by Controller General of Patent, who is the head of Patent Office, and he is also head of Design and Trademarks, Controller of Patent, and Date of Grant, all those. And then food, you have another note to which about which also we should be thinking about, and we should be making sense of. The fees for renewal of this patent, if it is to be maintained, will fall as has fallen due on 13th day of July 2007, and on the same day in every year thereafter. So initially it is registered for 2 years. If you so desire to maintain it or continue with the patent, then you will have to go on doing that. So how it should be done and things like that are indicated at the foot. So this is an idea of a patent certificate, and these are the ideas you may carry with a patent in respect of a patent. And as I said, there are 4 patent offices, and 4 patent offices are at 4 metros. You have one at Chennai, another one is at Bombay, and another one in Calcutta, and obviously you have one at New Delhi also. So these are the 4 places where you have patent offices. Now moving on, what is the subject matter? In what area is patent granted? If we go back to a discussion on copyright, in the case of copyright is granted in respect of literary work and artistic works, mainly literary work and artistic work. Here it is in the area of technology. I have already mentioned it, but to mention that in a systematic way, in that logical order, that the technology, patent is granted in any area of technology and science. So it is the scientific subject matter that gets protection as patents. That is something which you may keep in mind. Now I've got just an example of one of the celebrated scientists whose invention is on the screen. It goes without saying. Thomas Edison was an American inventor, scientist, and businessman. He invented many devices, including the dynamo and the first practical light bulb. He was born in 1847 and died in 1931. Just an information which will be contextual. But please note, to be an inventor, to be a patentee, your invention need not be breakthrough in the history, as in the case of a bulb or as in the case of a computer. It need not be a breakthrough. If you are carrying your idea of patent in the context of this picture, there is a disconnect. You will feel that patent is something not for us. It is something which is only for people of the level of Thomas Edison and Charles Babbage. Not so. And to illustrate that, I have got a picture over this picture in the screen, and kindly have a look at that. Have you come across this picture? Perhaps this would look a little funny, but over and above that, there is some technology in that. It's a pet umbrella. Pet is the dog that walks with you, and there is a combined leash. And this is a US patent. A patent number is written over there. You have a look at that. And you have an umbrella for a dog, which is not a very common thing, at least in India. So when you go for a pet walk in the eve with your dog on the beach, and if it drizzles, if it rains, you have 2 options. Either you may have to go back home, you may have to run back, you may have to be in a bus shelter perhaps, or you will have to carry the dog and you will have to carry an umbrella also. It spoils the very purpose of your walk, that is to relax. You'll be burdened with a dog and an umbrella. You won't feel relaxed. So here you have a problem. Problem is something which I explained. That is, it may look silly, but there is a problem that existed in society for people who go for pet walking. So here you have an umbrella. Usually you will have a leash attached to the neck of your pet, right? Though you like it so much, you will have a leash. And here there's a special kind of leash. If you look closely, I invite your attention. There are certain numbers in the screen, and there is a number 14 written over there, and just near the handle of the leash. There is a button. If you press that, the umbrella unfolds, ulta, as in the screen. So the advantage here is you need not carry the pet when it rains, or you need not stop your walk and run back or rush back. So this solves a problem. It is useful to the society. There is technology involved in it, and it is not known to anyone. So it is something new. There is some sort of technology, perhaps very simple technology, not as in the case of what you call, as in the case of a bulb. Maybe a very simple technology, but this is new and it serves a purpose. It's useful. So this is an example for a patent. This is something on which a patent has already been granted. Let's move on with our understanding. This is what I've already explained. And you have another running shoes with integral timer. This is something useful to sports persons, wherein you get all your statistics, required time, and all those things automatically recorded in your shoes itself. It should be useful to people who are practicing, or the sports persons who are who are into the the trade of running, playing, all those whatever statistics you require will get recorded in the shoes itself. So that is something new. There is some technology involved, and it's useful. Moving further with this, you have a projector phone screen patent. You have a projector phone with a pull-out screen that you can use as an extended display. That's also, it has got some better use, utility. You have a better thing, and it goes like that. And Apple wins a patent for a super smart pen, which predates LiveScribe. It's a special kind of pen. One of the notable things is this: whatever you write, of course, it has got very many features for this. Whatever you write will get recorded in the pen. Perhaps it's good, perhaps it is bad, but that is something useful, right? Now, some of our participants have their pen in their hand, and if you want to write something, you will have to write that onto a paper, right? Here, if it is getting recorded in the pen itself, it is advantageous, right? It's something perhaps crazy also to some people, but it is crazy people who come out with breakthroughs many times. So I just give a feel of patent and a kind of introduction to that. Now a little bit of history about patent law as such. Patent is a comparatively new thing in India. That would be the statement many people start with while talking about patent. But please note, it dates back. It is even previous to our first struggle of independence. It is older than even our celebrated, time-tested Indian Penal Code. The first patent law in India was in the year 1856. And mind you, Indian Penal Code was passed in the year 1860, and it was enforced in the year 1862. But you had a law on patent in 1856. The Act number 6 of 1856 on protection of inventions based on the British patent law of 1952 was made applicable to India also. And certain exclusive privileges were granted to inventors of new manufactures for a period of 14 years. It may not be as we understand today, but it could be a kind of a distant relative of what you have today, though it is not the patent as you as you get under the present act. But this is the predecessor of that. And in 1859, patent monopolies called exclusive privileges for making, selling, and using inventions in India and authorizing others to do so for 14 years from the date of filing specification was granted. And there was some sort of modification for the law of 1856. And in 1872, you have the Patents and Designs Protection Act, wherein you have two subject matters. One is patent, wherein there is a technological innovation, and another one is design, wherein aesthetic designs, industrial designs which appeals to the eye of the person. So two subject matters were combined into one law. And 1883, the Protection of Inventions Act. 1888, consolidated as the Inventions and Designs Act. And 1911 Act was the immediate predecessor of the 1970 Act. Still, if you go to some of the books on Indian law, you will definitely definitely get to read some of the cases, patent cases, which are under 1911 Act also. So 1911, the Indian Patents and Designs Act, two subject matters were combined into one. And in 1972, you have the present Act. It was passed in 1972 and came into force on the 20th of April in 1970. And it was the Justice Iyengar Committee which was instrumental behind the 1972 Act or 1970 Act, which is the present Act. But everything is different, but only the name. I'm making this statement very carefully. Everything is different, but only the name. Though the Patent Act, present Patent Act is known as 1970 Act, it has lost its soul and its blood. It was amended and thoroughly amended. There is a complete perestroika or a complete change as far as patent law in its nature is concerned. It was amended in the year 1999, 2002, 2005, etc. And the most notable amendment was in 2005. And this was to bring the patent law, Indian patent law, in line with the TRIPS agreement, the WTO agreement, which relates to the patent, the patent, international norms on patent. So there is a patent and there is a dispute settlement body under World Trade Organization, which is headquartered in Geneva. And US took India to the dispute settlement body with the allegation that India has a patent law which is not in conformity with the the TRIPS agreement. So that case went on. Ultimately, the dispute settlement body, the world, an international law enforcement body, you can say, international law interpretation body, and it said, yes, we see substance in what US says, and our patent law, Indian patent law, is not in conformity. Ultimately, there is very many things going along with that, a lot of international politics and things like that, which we may not go into. But ultimately, it was recast, I would say, and now we have the Patent Act 1970 as amended in 2005, and even after that. So that's a background of Patent Act. What do you call a brief history of patent law. Now the central question, as far as Patent Act is concerned, is what is an invention? This question is important. I say this question is important because patent law protects an invention. the very subject matter, the central pillar along which the patent law has been built is an invention. So the question of what is an invention is of central importance. Let's just read that. You have a definitional section. It is section 2, as in the case of almost every common law act. So section 2(1)(j) deals with the definition of invention. The definition of invention goes like this. Invention means a new product or process. We'll go again. Invention means a new product or process involving an inventive step and capable of industrial application. Invention means a new product or process involving an inventive step and capable of industrial application. Well, very deliberately, I have highlighted certain portions. I invite your attention to that. Kindly underline that in your notebook or in your mind at least, because these are the important requirements of a patent, the important requirements of patent. Now, if you go for a meticulous reading of that, you have 3 essentials. First one is the product or process could be a patent. It goes without saying, we have already discussed that. And such a product or process should be new. Usually it is termed, or it is used as novelty. Novelty is something like newness. That word is not there, but I think the purpose of language is served there. The purpose is served. Novelty is the requirement of an essential invention. Novelty. And second one is inventive step. This is the second requirement of a patentable invention. To be patentable, these are the qualifications, I would say. And the third one is capable of industrial application. So if you have an invention, you will have to convince the patent office that it has got these 3 essentials. If you can prove that your invention, the so-called invention, the thing which you call as invention is novel, thing which you call as an invention involves inventive step, and it has got industrial utility, then you are eligible to have a patent, and you'll be eligible to be called as a patentee. Now it's important for us to have an understanding about each one of these. What do you mean by novelty? What do you mean by inventive step? And what do you mean by capable of industrial application or industrial utility? These things will have to be clarified. We are going for that. By the way, do you have any clarification to make in the portions we have, the discussion we had till now? Do you have any clarifications to make? So you have a definition for novelty, which is under section 2, as in the case of any other law. Section 2(1)(l) says so. You can read. Ms. Rudy, would you mind reading that out for all of us so that I can have a break? Yeah. Unmute yourself and go on. You have not unmuted. You're not audible. Unmute your, please. Thank you.
Novelty, new. New invention means any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of patent application with complete specification. Either the subject matter has not fallen in public domain or that it does not form part of the state of article
Instead of art.
Section.
Instead
Section
of
2 clause 1 clause.
Yeah. Fine. So this gives us, and thank you, Mr. Rudy, for that. Novelty, the idea of novelty has been indicated here. New invention means any invention or technology which has not been anticipated by publication. Meaning to say, Anticipate means you're expecting something, or which is known. You can take it in that sense. It's not known earlier. It's neither published earlier. It is nor used or not known. Something which is not known, something which is not used, something which is not published. Three processes. These are the ways in which novelty is spoiled. If it is already published, then you don't have a novelty. If it is already used, then there's no novelty. If it is already known to someone, then it's not novel. There is no novelty. It is not new. And the idea of novelty extends to the whole of the world. Meaning to say, if any person or in the any far off corner of the world, if the technology on which you are claiming some sort of a patent, if it is known already, even in Uganda or in US or anywhere or Utopia, then you don't have a patent. And just think about the process through which we will ensure that this is actually new. It is not published earlier. It is not used earlier. It is not known earlier. It's so difficult for us to verify it, and patent law has a mechanism to verify this. Okay, so the idea here is, it is not known earlier, it is not published earlier, it is not used earlier. That is to say, the subject matter, the technology on which you are claiming a patent, has not fallen in public domain. It has not fallen in the public domain. It is not something which is already known. If it is already known, it is not an invention. It's our commonsensical understanding. There is a dictionary meaning of that. If you go by the literal meaning of it. And there is some sort of clarification for that, which I have boldened it, because that is a test actually employed by the courts and the authorities to verify whether something is already known, or whether something is novel or not. It says that it does not form the state of art. If the subject matter, if the technology or the invention you are claiming invention is already part of state of art. State of art technology, you might have come across those phrases used in relation to some machines you may purchase. State of the art technology is used in this. Here, state of the art would mean art is used in a very wide sense, so as to mean art as well as science. And here it would mean more as science. What's the present level of technology in the area you are talking about? If you are talking about a machine which can calculate, which can do calculation for you, which we can call as calculator, and a very a sophisticated form of calculator is known as computer, and you have things like that. And if you are coming out with that, you are Charles Babbage. And when you come out with that particular machine, which can do utility functions for you, and if it is already known to someone, if it is already state of the art, it is already used in the industry, or if it is already published, or if it is already known to some in the industry, then it is already part of the state of art. And if it is already state of the art, it is not new. It is already anticipated, we say. Anticipated here would mean it is already known. So it's already anticipated. It's already published. It's already used. It's already known. And if it is not already known, if the answer is negative, as in the case of COVID-19, if the result is negative, you have something positive, right? Same is the case here. If is it known? If the answer is negative, no. Is it already known? If it is already used, if the answer is negative. Is it already published? The answer is negative. All these negatives will make a positive. That's how it goes. It's simply flash my mind. There is an analogy with COVID-19. When things are negative, your RT-PCR test is negative, you are very happy. So is the case here also. If it is not known, not used, and not published, then you have something patentable. Okay, let's go further. The invention should not have been published in India or elsewhere. Any kind of publication, magazines, technical journals, books, newspapers, oral description in any seminar, conference, etc., will defeat novelty. If it is published in any of these forms, it could be any form of publication in a retrievable form, then it will lose its novelty, it spoils the novelty. The invention should not have been in prior public knowledge or public use in India, and of course you can say that it should not have been published elsewhere in the world. Though it is it is termed in a bit slippery manner, I would say the requirement is it's not known anywhere in the world. Put it in patent sense. The technology you are speaking about, the technology for which you require a patent, should not have been part of prior art. Prior art would mean already existing or gone by, already existing art, already existing technology. If your technology, the technology in which you have some pride, you say that I want a patent over that, this is not known earlier. But if somebody can prove that this is part of prior art, it's already known. If it is already part of prior art, your novelty is defeated and you are out of the patent office. You may not be thrown out, but your application will continue. Now we'll have to think further about novelty. Because novelty will defeat the very claim for patent. So it is important for us to ask the question ourselves, what is prior publication? The significance of this question is this: if there is a prior publication of the technology you are speaking about, in respect of which you are claiming a patent on, then that prior publication will defeat the first requirement, and there ends the matter. So obviously the question arises here is, what is publication? If there is publication, that defeats your novelty. And what's the kind and what's the extent of publication required? That's also important. Let me give an example which will illustrate the point. We read newspaper, right? You read Times of India, you read Hindu, you read Madhubhumi, you read Manorama, you read very many magazines, etc. And you are coming across a box news, a small one, perhaps a 2-column one, wherein it is stated that somewhere in US, a new machine has been found by someone, a person called Charles Babbage, which can count money with precision and dispense that into the human beings, account holders. Is this a sufficient publication? I want all of you to understand this question. Understanding the question is important, because a news of this, what do you call this manner, will this defeat the idea of novelty? Is this a sufficient publication so as to defeat novelty? So I'm talking about the second question in the screen, or rather I'm talking about both the questions together. So what do you mean by publication? If it is published, if it is just published, published in the sense some news about existence of such a machine, which will not enable, put it in different sense to understand the question better, which may not be sufficient for a person to manufacture this particular machine. The information, a 2-column information in times of India is not sufficient to make any one of us or the person who are working that particular area of science and art, science and technology. It is not sufficient even to enable such a person to, a person to enable him to make that particular mission. Is that a publication? Is that a sufficient publication? What's the significance of such publication? Is that a publication which will defeat the requirement of novelty? This is a question we will address. I hope the question is clear. Is the question clear, Ms. Disha? If you are there, Arpita, Krishnan, I know you people are not students in that way, but for me, definitely, you're all part of my audience. Mr. Nirmal John, Pooja Mol, are you all there? Oh, even Ranil is there. Hi. Shruti Vijayan. Yeah, I think the question is clear. I've got some responses and I'm happy about it. Thank you for that. Yeah. Now we have a case, a very old case, but I think this is one of the best cases where you can have a quotation to explain this idea. The case is Lallubai Chakubai Jariwala versus Chimanlal Chunilal and Company. The name is quite lengthy. Name of people are a bit funny if I say so. Lallubai Chakubai Jariwala versus Chimanlal Chunilal and Company. There are certain observations or quotations in this case which will throw some light on the idea we are on. Our website subject to Copyright Act and Patent Act. Mr. Nirmal has a question which I will definitely address once I complete this. I'm into something. Mr. Nirmal, hi, thank you for the question. I'll address that once I complete this. So with regard to sufficiency of knowledge. So how much knowledge, how much publication will be a sufficient publication, sufficient knowledge, so as to defeat the idea of novelty. If there is sufficient information out in the open, accessible to everyone, then it is sufficient publication, and that will defeat the idea of novelty. So with regard to sufficiency of knowledge, the earlier publication must give the requisite knowledge clearly, and it is not enough that it merely gives the means of attaining such knowledge. The sentence may not be a sufficient sentence for us to make the idea understand, to make us understand the idea. It must give sufficient information to a workman skilled in the particular art or craft in order to enable him to carry out the invention. And this is the idea I'm trying to make here. We'll go once again. The information that is published is that information which you have in your hand. The person who has come against you. You are claiming a patent, and there is another person who has come against you. And that person has some information, and that information will be considered sufficient to defeat your novelty. Only if it must give sufficient information to a workman skilled in that particular art, skilled in that particular area, the person who is working in that area. If it is a pharmaceutical patent you are talking about, a person working in the area of pharmaceutical. If you are talking about automobile, a person who knows the technology, the level of technology at that particular point of time, at the date of application. And if you show this information to that particular person, the workman's skill in that particular art, that information or the publication should enable such a person to carry out the invention, manufacture the invention, or he should be able to make it. If you're speaking about a machine, that information should be sufficient to enable the person to make that particular product, or if it is process, that carry out the process. Now go back to our example of Times of India and the 2-column news, which says that somewhere in Uganda or somewhere in US, somebody has found out a machine which can with precision account currency and recognize different currencies and dispense that with precision to people. Now the question is that 2-column news in Times of India or in the Hindu is sufficient, and will that enable a workman, a person working that particular area of making machines of that sort, enable that person to carry out the invention? That is, whether that is good enough for that person to manufacture this particular thing. If it is sufficient for that, then it is a sufficient publication which will defeat the requirement of novelty. The cases, there are very many cases wherein you have similar observations, but I think this is one of the observations which make the point. You may refer to other cases also, but this is definitely a case which is a good enough, a sufficient observation to make us understand the point. I think we will stop here for the day. If you have any clarifications to make, I can do that. Before we break for the day, I have a question from Mr. Nirmal John, and he raised the question whether websites are subject to copyright and patent. I would say there are two parts for the question: whether websites are subject to copyright. Definitely yes. Whether websites are subject to patent, I'm a bit perplexed to say that, because if the is making a website involves a patentable process or a patentable product, definitely it is not. Can that be called as a product or not? That's a interesting question. At least to my knowledge, that question has not been addressed by any courts to my knowledge. So as technology as we understand may not be involved in the making of a website, you may not say that, you may say that patent is not applicable, but definitely copyright, definitely it comes in, because copyrightable subject matters can be made available in a website. So I think that is sufficient response for the question. Does that serve the purpose, Mr. Nirmal? Is he there? Hi. Hello. I think he's already gone. Is he? Yeah, he's there. Mr. Nirmal John. That's fine. Yeah. So isn't website the expression and not a technology? Yeah, that's what I said, Rani. As far as copyright is concerned, definitely an S. As far as patent is concerned, as the subject matter cannot be considered as a patentable subject matter. But the way in which you make a website, and the website as such are different, right? The way in which you make a website might be eligible for, there is a possibility, remote possibility. But website as such may not be eligible for patent. That's my response too. Thank you for the input. You have something to add, Ms. Raniel? You can definitely.
Yeah, so, no, I was thinking, so far, to my knowledge, when you are creating a website, you are putting use of, or you are making use of the existing technology. If, for example, you're using softwares, you're using, for example, at LJRF Voice, we are using WordPress to create the LJRF Voice website. So it would be like we are already using the existing technology of softwares, like the existing technology of creating codes. I mean, not creating codes, of putting together codes. So I don't think we have any element which would enable us to have patents, but we might have some kind of element to enable a design protection, because we have designed it
Design
that way. But I
protection
don't think
definitely.
it's patent. Maybe we can create a software which enables us to have has to create a website more easily. Then that software would be eligible for patent, but not the website that has been created, right?
Right.
Again, it would be like,
But
and it
again,
would be like
but
protecting
again
the
in India,
fundamental rights.
software comes under copyright law only, right?
Yeah, yes. Software,
And,
yes,
and,
exactly.
and I make a distinction between website as such and the way in which you make a website. The way in which you make a website is, I'm making a distinction between these two here. So if I understand Nirmal's question, the way in which I understand is this: is website whether website involves any pattern? So definitely, as you were also saying,
Sorry, I think I was
definitely.
also coming. Sorry, I was also trying to come to the question about software as well, because I think softwares. This is something I had a debate. This was debated in one of the at a place that I'd once worked at. There was an NGO that's called Software Freedom Law Center. So they'd actually done a lot of work on the demarcation between software and websites. Are they subject to copyright or are they subject to patent law? So, and this debate about software in particular was also could go either way.
So software is definitely a difficult subject matter, because there are jurisdictions where softwares are under patent law, but in India it comes under copyright law. So definitely the very nature of the subject matter makes things a little difficult. So in the Indian context, definitely we put it in the copyright basket. But as you might have argued, it has got certain features which can definitely bring that under patent law also. Of course, if it is, if it is put into something hard, hard in the sense soft versus hard. Hardware, which will look like a machine, then you get protection for that particular software also as a patent. That's how the other jurisdictions carry out things. So anyway, thank you so much for the question and also for the discussion. Thank you for the input, Mr. Daniel also. Thank you so much. So I think that's it for the day. Thank you, Mr. Puchara, everyone. Thank you, Sophie, sir. Bye, sir. So with your permission, I will. Thank you, sir. Thank you, sir. That's it for the day. Thank you.
Thank you, sir.
Thank you.